Health and Scott and White Healthcare.
Jennifer Cheek on behalf of Door Control Services.
All right, let's get started.
And then, well, defendants over at Door Corporation, Door Services Corp., Leon Carter and Joshua Bennett on behalf of those defendants.
Great, thank you so much. Let's get started.
All right, may it please the court, Your Honor, we're here today on, a few motions. A couple are ours and one is, I guess, the parties, but a motion to enter a scheduling order. We'll get to that, I guess. Well, we can take them up in whatever order the court wants. There's the two motions that we have set for hearing today are our amended summary judgment motion and our special exception.
Do you want to deal with the scheduling order first?
Sure, that may make sense.
Let's talk about that.
Yeah, so after our hearing last Monday, parties went back and checked. I think, and Mr. Simmons and Ms. Cheek will correct me if I'm wrong, but the defendants are all on board with the July 19 setting or the July 12 setting for the special preferential setting. So I think that may moot in part. We're going to have to rediscuss the scheduling order if that's the case, because the scheduling order that is being put before Your Honor now is based on a trial that's almost a month later, and that's going to compress, I think, some deadlines, but or at least in our position, it ought to. But if Your Honor is still amenable to that, the defendants are open to.
Talked about it. You'd have to agree to be to a 6-person jury if we're in code red, right?
No. What was discussed last time is if we were in August 9th, we'd have to make that agreement.
You're right. That's correct. Yeah, July 12th then would be fine. Does that work for everybody?
I don't think that works for Ms. Metcalf, but I'll let her tell me that.
Okay.
Your Honor, July 19th was another date you proposed. That one does work with a couple of, I want to make sure that we're very clear. We still have a couple of depositions we're trying to get scheduled. So we just need to make sure that we get those scheduled. And then also, I did want to ask Your Honor regarding witnesses. Do you allow them to testify via Zoom in your court?
Yeah.
Because that may preclude some of the issues.
Absolutely.
Okay. All right. Then I think we're down to potentially 2 depositions that we would need to make sure that we get scheduled. Okay. So I know we have requested dates on one of them. For Dr. Shaw, one of his treating physicians. Oh, I'm sorry, Your Honor.
Just one thing with July 19th. You guys, if I recall, this is what, a 4-day trial or 3-day trial? Is that correct?
Well, we're hoping for 4.
But my only issue is that if I don't mind if it's up to 8 days, but after 8 days, it gets to be very problematic. And so, but it doesn't sound like it's going to go that long. Is that, everybody agree?
I would not anticipate it going 8 days, Your Honor.
Mr. Bennett?
Yeah, we absolutely agree with that. We think it's closer to 3 or 4, but certainly no more than 8.
I think 4 sounds about accurate, but I don't anticipate it going 8.
Okay. All right. Rhonda, we'll go ahead and specially set this on July 19th. Let me make sure we just haven't had any other special settings in the interim.
And I think, Your Honor, that will do away with our motion for the scheduling order at this point, because we'll need to recalculate dates.
Yeah, we're still good on the 19th. All right. Rhonda, go ahead and specially set that on the 19th. All right, what's next? What else do we have? We have a summary judgment and one other motion.
Correct. Time permitting on the other one, but it's a special exceptions. There's only a few issues remaining there that didn't get corrected in the 5th amended petition that we'd need to take up. But we're happy to argue the summary judgment motion first.
You have 30 minutes, so whatever you prefer, whatever you think is the most important thing for me to hear.
Yeah, we'll proceed with the summary judgment motion. Let me go ahead and share screen. So I'm taking this from the first 2 pages of plaintiffs.
There's a Matt Braylon and Lloyd Anderson here. Are they on your case?
Mr. Breland, I believe is. I don't know about Mr. Anderson.
Mr. Anderson, what are you here for? Anybody know who that is? Okay. All right, go ahead, Mr. Bennett.
All right, I'm taking this from pages 2 and 3, my opening comments about what the facts viewed in the light most favorable to the plaintiff are for purposes of summary judgment. We can take those as true and we should still win on 3 grounds. Number 1, I don't usually move for summary judgment on this first ground, but it applies here, and that's causation. There's no but-for cause here, and there's, at best, as far as my clients are concerned, Overhead Door Corp and Door Services Corp, at best, the plaintiff's causation case is one where we created a condition in which Mr. Bostic could be injured, and that's never enough to show causation as a matter of law. So causation is the first one. The second one is the hazard that Mr. Bostic actually complains about, which is an automatic door opening automatically. We'll see why in a second and look at their view of the facts and their response, is an open and obvious hazard as a matter of law. And that is a question of law for the court. We think it applies here, and that it absolves of any duty to warn, which is the duty that we're accused of violating. And the last one is just no common law duty as a matter of law to warn as for a marketing defect or any other purpose in general negligence or products liability. Obviously also a question of law. So I think at the end of the day, even when you view the facts in the light most favorable to the plaintiff, those facts don't justify at least our clients going to trial, and the remaining defendants and plaintiff can sort it out before a jury. So again, this is all taking sort of a high level view of the plaintiff's response, pages 2 to 3. I'm just going to share a screen real quick. Oh, it's been disabled. Can I?
Let me fix that. Go ahead.
All right. So this is just a quick diagram to show kind of what happened. It's undisputed that Overhead Door, you'll see it referenced as Horton Automatics. It's just a division. It's not a separate entity. Overhead Door Corp is the operative entity here. It makes and sells a low energy door opener, attaches to a big heavy door, doesn't make the actual wood part. You attach it to this large heavy panel, and it can open it automatically. And that's what we sold. We sold that to Door Services Corp, who's a wholly owned subsidiary, separate entity from Overhead Door Corp. Door Services Corp then contracted with some contractors that were building a hospital for Baylor Scott and White. So Baylor Scott and White didn't have possession of the building. It was being built. And as it was being built, Overhead Door sold these openers to Door Services, who then in turn contracted to install them for the hospital. 17 sets of them. This case only concerns one of those sets, but that's the lay of the land. 2015 install was made. Overhead Door was, not Overhead Door, but Door Services Corp was fully paid for its services installation-wise. And that included a number of things, and you can read this in Michael Milburn's testimony, which is pages 56 and 57 in our amended summary judgment motion, where he says, we got fully paid. Somebody checked off on all of our steps, and that's the only way we would have got fully paid. And that included signage and other things that we would have had to have put up. So that's the lay of the land. Those facts are undisputed. More than 730 days later, this is what happens. I'm going to show the video to your honor. We have video of just the incident in question. Obviously can't attach it to a brief, but we've all who've been on this case seen this more times than we care to admit. But it's just these first few seconds. So this, the figure emerging from the door that you see is Mr. Bostic. His left hand is on the door. It's an automatic door. He's waving to someone. And I'm going to just slow down the playback speed just by half so we can just see what happens. But this is half the actual speed. So right there, he's let go of the door completely. The door is closing on its own power. And if you look on pages 2 and 3 of the plaintiff's recitation of the facts, the way these doors operate is the sensors right now are not on, because if they were on, the door would always constantly be in a state of perpetual opening, right? If the sensor's on and it detects motion and the door is supposed to close, then it's going to reopen. It's never going to close once it's open. So the way the sensors work is once the door is fully open, that sensor is operative. But as soon as the time delay expires, and that you can set those at different time delays, the door starts to close and the sensor's locked out. So at this point, the door is closing and that sensor's locked out. He's let go of the door completely. He then stops the door. He's holding on to the door. And then somebody pushes a button, presumably a hospital person. That seems to be the consensus. It's certainly plaintiff's position. The door opens, Mr. Bostic falls.
Okay.
Mr. Bostic's contention is that not that the sensor failed at that point because the sensor was off. Mr. Bostic's entire contention, and I'll just show it from his own response. Is this. The sensors should have kept the door open for longer than it did. And that had the sensors done that at the outset before the video starts. Sadly, we don't have more video, but we have what we have. And Mr. Bostic's position is, had the sensors been set so that the door would have stayed open, it never would have started closing. He never would have had to hold on to it. Then when somebody pushed the button to open it, again, a hospital employee, according to Mr. Bostic, pushed a button and started opening the door, then he never would have fallen. One other important piece of set of facts that comes into play for overhead door is what our alleged involvement in this is. There's sort of two sets of facts. According to Mr. Bostic, overhead door, well, Door Services Corp, the actual installer of the doors, ought to have, and they say that we didn't, but ought to have given the hospital an owner's manual and some instruction on how to use the doors. Now, keep in mind, the hospital hadn't even taken possession of the building by the time we installed these doors, but just set that aside. We don't need those for purposes of the summary judgment motion. We'll just take that as a given. That's their allegation. There's actually no actual evidence disputing or giving the evidence that we did give the owner's manual and an instructional video to the contracting party, right, which is the contractor with whom the hospital was working. But we agree that we didn't give it actually to somebody at the hospital. So what Mr. Bostic says is, by failing to deliver an owner's manual and that training video, you failed to train or warn the hospital, who then in turn failed to train or warn its own people or Mr. Bostic. And then that if the sensors weren't set correctly, maybe they weren't set correctly in 2015, somehow you're still liable, Overhead Door Corp and Door Services Corp. So there are several legal reasons why that theory is untenable. And the first I'll just start with, again, is causation. The undisputed evidence in this case, and I want to show some important admissions that the hospital's made that severs the chain of causation, at least as far as Overhead Door is concerned. So Overhead Door served requests for admissions on the hospital. And one of the issues in this case is, did the hospital do daily safety checks? It's undisputed that they did not. Mr. Bostic wants to put that on Overhead Door and say it's our fault because we didn't give them the materials they needed to know about daily safety checks. And had they done daily safety checks, they would have found this defect and Mr. Bostic wouldn't have been injured. The problem with that theory is the hospital has said, we follow a set of standards. Those standards do not require daily safety checks. Ergo, we do not do them. So in other words, there's no but-for cause for failing to tell the hospital about daily safety checks, even if you assume that we didn't. Again, there's no evidence that that's true. But even just going with plaintiff's argument on what the facts are, which is an evidence, there's no but-for causation. You can't have a but-for cause if the hospital says we were never going to do daily safety checks, even if you told us that. And they've plainly admitted in these 4 admissions that that's the case. Same with the signage. You didn't warn me adequately because you only had partial signage, says Mr. Bostic. Well, our owner's manual shows what signage they needed. The hospital's representative says we are required by law to have that manual in our possession. There's no evidence that they don't have it in their possession. Ms. Radke's undisputed testimony is that they did. But again, even if you assume that they did not, it doesn't matter because the hospital was never looking at the owner's manual as the guide in any event. You have to look at the standard that the hospital's views. You look at this NFPA 101-2012 standard. And if it's not in there, then we don't follow it. That's our key. That's our guide. So whatever Mr. Bostic has to say about what we should have done or didn't do in 2015, more than 730 days before his accident, it doesn't really matter because it's not a but-for cause. That's the Doe case that we've cited. There's many others, but the allegation there was, well, if you'd performed a background check on this person who abused these kids, he would never have been in a position to do that. Well, says the Dallas Court of Appeals, what would the background check have shown? Nothing that would have led them to believe that he would have done anything like he did. So no causation as a matter of law. That's exactly what this case is. The second causation reason is that at best, even if you view the facts as Mr. Bostic says they are, all overhead door could have done in 2015, again, more than 730 days before the accident, is create a chance for him to be injured and not have actually caused the injury. We've cited a few cases on this. Probably the best one for the court to look at is the Rammerstead case out of the Houston Court of Appeals. I mean, it's highly analogous to this case. In that case, what happened was there was a negligently installed clamp of some kind that keeps a power line up in the air, prevents it from falling down. Well, that clamp failed and fell off, causing the power line to fall, which then caused traffic lights to fail and an accident to occur. The plaintiff sued the power company saying my car accident happened because your clamp was negligently installed 33 years ago. And the Houston Court of Appeals took all of that as a given, didn't even take.
But isn't that a different situation here? He was actually hit by the door, right?
He was actually hit by the door, yes, but not because at the time of the injury, the sensor had failed, right? The sensor's not implicated at the time of the injury. The only thing that the sensor failing does is it creates the chance for him to be standing, holding the door, according to the plaintiff, while somebody else pushes the button. The pushing of the button is an independent cause, just like the car wreck, right? So in the Rammerstead case, and there's a number of these, Union Pump, the Albritton's another, where you put the plaintiff in the position to be injured, but the actual thing they're complaining about that you did negligently isn't what causes, there's no direct causal link other than putting them into place to be hurt. So their allegation is 2 years ago, you didn't set the setting correctly on the sensor, right? In the intervening more than 730 days, once that sensor didn't work correctly, it wasn't that the sensor's failing hurt me. It's that because the sensor failed, I was in the intersection. If you're in the Rammerstead case, where I was near the failed pump, if you're in the Albritton case, the Union Pump case, and then something else happened to cause my injury. It's not the sensor's failing that when somebody else pushed the button that caused Mr. Bostic to be injured, because that sensor wasn't ever on at any time during the video we just watched, and that's undisputed.
We have about 1 minute left because we have to let the other side have equal time.
Understand. So between those two reasons, causation as a matter of law, their claim fails. The last one, and we've briefed the other issues with duty. I would draw the court's attention to Elephant Insurance, which is a case that came out 2 weeks ago. A car insurer told somebody, hey, go out and take pictures of your car accident, didn't warn them about the danger of oncoming traffic. They did that and were hit by oncoming traffic, sued, and the Texas Supreme Court 2 weeks ago said no duty as a matter of law to warn about that kind of defect. No duty on the part of the insurer, and there are comparable reasons for it to apply here. There's other cases we've cited. The last thing I want to talk about is the open and obvious hazard. You can look at the undisputed evidence, and there's two ways we win on open and obvious hazard. One is if you just apply Mr. Bostic's actual knowledge. He walked through these doors, he saw them open automatically, knew that they were automatic doors, and knew that he ought to get out of the way of automatic doors, but didn't. knew that they could open automatically and stayed in front of them. So under the actual knowledge standard for an open and obvious hazard, it was open and obvious to him subjectively. But we can also go under the objective standard,
Mr. Bennett,
which is,
let me hear from the other side at this point.
okay,
Response?
Yes, Your Honor. And if I may share the screen,
You may.
I think I can get through this quickly. Overhead door makes a lot of claims in its summary judgment, some no evidence, some under traditional. So I'm going to kind of go through these. I'm going to skip through the first two because I don't believe I heard Mr. Bennett talk about these. These had to do with ODC's allegation they were entitled to the protections afforded to property owners about premises cases as far as contemporaneous activity, controlling the premises. We haven't talked about those, so I'm going to go on down here. Let's see if I can make this the PowerPoint. There we go. So we're going to talk about, we have claims against overhead door for multiple things. It's not just setting the sensors. It's when they went out there, they were supposed to provide instructions to the owner on how to operate these doors, how to do a daily safety check, and they were supposed to provide owner's manuals. Now, if we look at the evidence that has been presented to the court, I'm sorry, did that change things? Let me try this again. Here we go. There is testimony from Overhead Door's own expert, and Mr. Bennett was correct. When this hospital was originally constructed, I don't even know that they had electricity in, but their own expert talks about the installer is responsible for sending a technician later to do the final tune-in and ensure all the adjustments are properly set. And according to AAA DM, Adam, the company has to offer the familiarization session with the owner, explaining how to do a safety inspection. So that's a part of the duty set by their own folks. Mr. Milburn was their technician that went out. And according to Mr. Milburn, if you look there at page 41, we asked him, did you show anyone how to do a daily safety check as referenced in the owner's manual for the doors that issue in this case? His answer was no. We asked him if he was aware of anyone with Texas access controls, which wasn't in Mr. Bennett's diagram, but that is also under the overhead door company umbrella. And did anyone with that company ever show anyone at Baylor Scott & White how to do the daily safety check? The answer was no, from their own employee. Mr. Cadell, the supervisor of facilities there, said he had never been told that there were aspects of the door that should be inspected daily, and he didn't do so. Rodney Lott, the manager of the facilities department, he did not know, and he had never done a daily safety check and had never been shown how to do one. Jennifer Radicke, the tech support administrator that we deposed, I asked her if she'd ever seen the daily safety check of the owner's manual, and she said that was the first time she had ever heard of it. That was October 27th of 2020, almost 3 years after this occurred. Now, so overhead door claims we have no evidence that they failed to provide instructions or that they failed to provide the hospital with the owner's manual, and we have provided that. ODC claims that there's testimony unequivocally that the hospital did or does have an owner's manual. And that's just not the case, Your Honor. We've presented evidence in our response that they did not have the owner's manual. The manager of facilities department didn't know about it. The supervisor of facilities had never seen one. We asked the hospital, we asked them to produce an owner's manual, and they said they had none in their possession. So certainly the evidence is not unequivocal on this. Now, overhead door had raised the learned intermediary. We'll skip through that because I think we've shown they did not provide the third party with the warnings, and they did not show that Baylor Scott & White was adequately trained, familiar with the product and its safe usage. So now we're going to get into the causation. They claim that there's no evidence any design defect caused Mr. Bostic's injuries. They claim the hospital would have followed the owner's manual's instructions. We have presented evidence from Dr. Warren Davis that the lack of sensors were part of the cause that the door hit him. And if Baylor, Scott & White had done daily safety checks, they would have discovered the sensor issues. So I think I want to make sure that the court is understanding our contention is that this door was supposed to have these safety sensors. In fact, safety sensors were installed, but the testimony is undisputed. They were not set properly. The pattern size of them, which they called the safety zone, was not set properly. And because of that, the door, when Mr. Bostic was in the safety zone, the door began to close on him. That is the first piece of this that is very important. The sensors, before the door should start to close, should look down, see him in the safety zone, and the door should remain open. That's undisputed. Unfortunately, the safety sensors were not properly set. The door begins to close. Mr. Bostic reaches behind him to grab it to allow his pastor to enter the hospital. And at that point, apparently someone with the hospital hits a button and the door switches directions. Now, Mr. Kringle was asked about this. If he believed, this is the defendant's own expert, was also asked if he believed that if the daily safety check is not performed, it's foreseeable that injury would result to those using the doors in the hospital. And he said it's possible. So we have Dr. Davis saying it's the sensors not activating that were a cause of this, and they would have been discovered during the safety check, and their own experts saying, yeah, if they didn't do it, it's foreseeable. Now, Mr. Bennett talked a lot about Baylor, Scott & White's answers to admissions, and that this somehow breaks the chain of causation. But actually, the testimony from Baylor, Scott & White's own expert was that if Baylor had received this instructional video that the installers were supposed to provide, then he said he's sure that they would. The video talked about doing these daily safety checks, and the evidence, there is no evidence that that was ever given to an agent with Baylor, Scott & White or Baylor, Scott & White. No evidence has been provided at all that that was ever done. In fact, when we deposed Mr. Milburn, their installer, he just said he didn't remember. Now, when you go to this, Baylor, Scott & White, the hospital's own expert, said that if they had received this, he said, and Mr. Bennett asked him, well, would the hospital have made that part of their safety plan? He said, I'm sure that would have been best practice. And, you know, everybody wants their organization to be safer, so I'm sure they would have done that. And Mr. Bennett questioned him further, well, they would have done what? And he said they would have taken the course and used whatever you guys had told them. Mr. Bennett, to perform daily safety checks, their hospital expert, that's what you said, yes, sir. So there is evidence that would have made a difference. Mr. Bennett said there was no evidence Baylor, Scott & White, or he says Baylor, Scott & White was never going to follow the owner's manual's instructions. And there's no evidence the hospital was never going to perform daily safety checks. And the evidence is they were never provided with this information by Overhead Door. He quoted the Doe v. Boys Club of Greater Dallas case, and that case is distinguishable. In that case, what the court said is, hey, there's no evidence that if the Boys Club had known of this guy's intoxication charge, that they still wouldn't have hired him. There was no evidence of that. Here, there is evidence that we have presented that if daily safety checks had been done, that Overhead Door was supposed to instruct the owners on, that they would have done them and the sensor problem would have been detected. Now, as far as the open and obvious, in order to, that's an affirmative defense that they have to prove. And they have to show that the plaintiff had knowledge and full appreciation of the nature and extent of the danger. They can't do that here, Your Honor. They have not met their burden. They did not show that Mr. Bostic was aware of how door sensors worked and that they were not working properly while he was standing in the safety zone. There's no evidence he knew that a nurse would activate the door while he was in the safety zone, causing it to switch directions and hit him. And there's no evidence he knew or appreciated the danger of a 130-pound door striking him and the extent of that danger. Their own expert, Mr. Kringle, I asked him about this open, obvious thing, and what he testified to is that the sensors not working correctly would not be visible to a visitor at the hospital. That the only way that they would know or have any idea what the pattern size is if they're an automatic door technician. So they have not shown that Mr. Bostic, just because he had been through automatic doors in the past and a nurse had opened this one for him, they have not established their burden to meet the open and obvious defense.
How do you distinguish the elephant insurance case?
Yes, Your Honor. The elephant insurance case, in that involved duties of an insurance company to their own insured under a contract. It's a different case. In that case, there's no evidence that there was a contractual duty by ODC to the plaintiff. We have not alleged that, and ODC has not provided any contracts. I would say that is similar to the Timberwalk case, as far as the insurance company there had no duty to the acts of the third party it had no relationship with, and that was the driver who hit the plaintiff. Here, we have alleged overhead door had duties to the hospital, and it failed to meet those duties. And their own expert acknowledged that they have those duties. So it is certainly distinguishable.
Okay. Have you guys submitted a brief book that has remind me again of all of the cases in it?
Yeah, yes, Your Honor, we have for our cases, yes.
Okay.
Well, do you want like printed cases out? Like, you want us to send you a binder of all the cases cited? Is that what you mean?
Well, what I was hoping to have is a binder that has both sides, motion, response with cited cases and highlights. Have you already done that? I don't recall seeing that, but I could be wrong.
I thought we had, but let me check with my staff to be sure.
Okay.
But if we haven't, we'll send you one with Ms. Metcalf's and our own, the full briefing on this. But can I respond to a few of the points she's raised?
Unfortunately, let me just see if the next hearing is here. If it's not, that you can keep going, but I can't get behind today. Is anyone here on the Velasquez case? Anyone here on the Velasquez case? Mr. Vaught, are you here? I thought I saw Mr. Vaught.
He's on. It looks like he's on mute, Your Honor. This is Daniel Ramon. I'm on behalf of the defendant, but I see Mr. Vaught.
Y'all still need a hearing today or no? Mr. Ramon, do you need a hearing today?
Yes, Your Honor. I believe we do.
Okay. All right. You have one scheduled for 10. So if you were going to waive your hearing, I was going to let them keep going. I'm going to take this under advisement and hopefully get you a decision within the next month. Okay,
we'll submit a letter brief responding to Ms. Metcalf's points then, Your Honor.
Okay, and include that all in that one notebook with both sides cases and a full brief book.
And we will
Understood.
get that
Thank you.
The next 48 hours, we'll get that to you.
Just get it to me by next Friday or by this Friday. By this Friday.
We'll do.
We'll do it.
Thank you.
Thank you for your time, Judge.
Thank you, guys.
Are we excused, Your Honor?
You are.
Mr. Ramon, can you hear me?
Yep, we can hear you.
Okay, thank you, Your Honor.
All right, Tony, let's go on the record. Let me take this down. Okay. Dariana Velasquez versus Cohen Esri Communities LLC. Cause number DC 218215. Tony, we're going on the record. Counsel, make your appearances.
Alan Vaught for plaintiff.
Daniel Ramon for the defendant.
Let's proceed.
Your Honor, this is Alan Vaught on behalf of the plaintiff. This lawsuit was filed pursuant to the Federal Fair Labor Standards Act and pursuant to state common law claims for quantum merit and money hadn't received relative to plaintiff and 282 other individuals who were leasing agents for defendant. the case is based upon unpaid overtime wages due to bonuses and per diem pay not being included in the regular rate. But ultimately, the parties exchanged data, reviewed that, and we reached a settlement agreement signed by the parties, and we have submitted for approval that settlement agreement. And this process, Your Honor, requires two steps. First, it requires the court to grant preliminary approval of the settlement agreement and conditionally certify a limited collective action for the FLSA, putative collective action members, and certify a class action for the state law class action, putative class action members. And they're all the same individuals, but we just need two classes certified. If the court finds that the settlement is fair and reasonable, then we'll go through the issuance of notice process. The parties agreed on a third-party claims administrator, CPT group, to issue the notice, claim forms, opt-out forms, process payments, process objections, et cetera, if the court grants preliminary approval. And then at the close of the notice period, which is 60 days after the order granting preliminary approval, sometime thereafter, we'll have a final approval hearing where we will present to the court the data that the claims administrator has on the number of claims submitted, the number of opt-outs, et cetera. And the court can then determine if it grants final approval of the settlement. And if so, then settlement checks will be issued to plaintiff and the 282 putative class and collective action members. The maximum gross settlement amount we reached in this case is $88,134.18. The settlement agreement sets forth, well, just let me back up. I reviewed the data from defendant on what the overtime rates should be for everyone, and did the math on that, and it's reflected in the settlement agreement. And the maximum amount for them would be $58,756, but we have a settlement agreement for $88,000 and some change. That's to account for legal fees. The claims administrator fees alone are about $12,500. So ultimately, there's a formula for allocations of the maximum gross settlement amount to each collective action member and class action member, that is, those that don't opt out, for the amount of money they would be paid that's attached to the settlement agreement. The claim forms, the opt-out forms, and the notice form especially, it complies not only with what's needed in an FLSA notice, but also under the requirements of Texas Rule of Civil Procedure 42. For example, letting the putative class members know they have the right to retain their own counsel if they want to. Texas has some stricter requirements in most states, obviously, on class actions. But, Your Honor, we believe that the settlement is fair and reasonable, both under the FLSA and under the state law claims. The class counsel fees, well, we're asking that the court appoint me as class counsel, and I've provided as Exhibit 3 to the motion my declaration of my qualifications in the area of wage and hour. It lists the legal fees that ultimately we'll ask the court to approve in the final hearing, but those will not exceed the legal fees I had as of December 16, 2021, so that the class members are going to know pretty well, if the court approves it, the order as presented, what they're going to get in the case, other than payroll tax deductions, which the claims administrator will facilitate.
Okay. Anything else?
No, Your Honor, other than if the court does grant preliminary approval, there's a blank in the proposed order for the date for the final approval. And we request that date be on or after 220 days from the date of the preliminary approval order, because it's going to take that long for the claims administrator to facilitate notice, process claims, do the other work required, get the data back to defendant and myself, and then for us to prepare and file the motion for final approval. That's
And
all I
Mr.
would add to it.
Mr. Ramon, did you want to add anything?
No, Your Honor, I think Mr. Vaught summarized it fairly well. The only thing I will add that, of course, the motion itself contains, I think, pretty detailed briefing about each of the elements that Mr. Vaught just discussed as well. But if you have questions, happy to answer.
What month would you like to do this hearing, final approval hearing?
That requires me to do math, doesn't it, Judge?
Alan, I think we said about at least 7 months, right?
Well, I 220 days after the order of preliminary approval. So hang on one second.
You said what, 201?
220 days.
Okay. So sometime in maybe December.
I think that puts us near the end of the year.
Yeah, to the 220 days, assuming the court entered the preliminary order today, 220 days would be Thursday, December 15th.
Okay, you want to do it December 16th, or do you want to do it in January?
As long as I don't have a trial in December. Your Honor, December 16th would be acceptable for plaintiff.
And same for defendant, Your Honor.
What did you say?
That is also acceptable for us.
Okay.
And Your Honor, with regards to the amount of time required for that hearing, I expect it will be similar to this hearing, but we won't really know that until we get the feedback from the third party claims.
If we have any
administrator.
opt-outs or things like that.
Yes, sir.
Why don't we set that at 3 p.m. just in case? And I will go ahead and scan this right now and send it to the clerk's office, and hopefully they'll get it scanned in today.
Thank you, Your Honor.
All right, anything else, guys?
Nothing for plaintiff.
No, Your Honor.
Let's have a good day.
Thank you.
Thank you.
Morning, Judge.
Good morning. Is Mr. Anderson here in your case, Lloyd Anderson?
I don't know. Some people filed answers today and I didn't get a chance to look. So I don't know who the lawyer is.
Rhonda, are you there? Rhonda, are you there?
Yes, Judge, I'm here.
So that case we just had with the class action, the DC 218215,
Uh-huh.
go ahead and put that on a DWAP docket for the last Monday in January
Okay. D1.
of next year. It's on in May. It's too early to do it in May, so we're gonna have to just put it next year. But I don't want to have anything on it, so just go ahead and do a new DWAP for that for next January.
Will do. Okay.
I guess I should tell you my specially set case in June settled.
Oh, with me?
Yes. June 13th.
Not the Crapo case. That's not you, right?
No. We came in oh gosh, April to try the case, March. And the day before we bumped it to a special setting.
Okay, let me see. And it's settled?
It's settled. We're working on final documents. We have our Rule 11 signed.
Is that, let me see.
No, you'll be happy to get 2 weeks
Oh,
back.
Mabanta. Yeah. Oh my gosh. Yeah, that would have been an interesting case to try.
I'll take it.
All of June back.
How long is it going to take you to get that? Do we want to put it on a 30-day DWAP or what do you want to do?
I think a 30-day is fine.
Hey, Gary.
If I don't get final documents to them today, it'll be tomorrow. So, and they're pretty quick.
There is a 15-minute Zoom involving a court hearing that I'm just interested in. It's got nothing to do with me. It's about to start. Just hang out if you're here. I'm sorry, but it's just starting.
Whoever is speaking, if you guys could, I don't know if you realize you're unmuted. Okay. All right.
Pardon me, were you talking to me, Judge?
I think so. Were you the one just speaking that say you have a hearing that doesn't apply to you?
Oh, Judge, I apologize. I didn't know I was on. I was talking to somebody else. I'm a spectator in this hearing. I apologize.
Oh, no problem. Okay.
I'm here to look at the 1015 hearing, Judge, just as a spectator.
All right, let's go on the record on cause number DC 1913360, Jackson v. Preston Tower Condominium Association. Council make your appearances. All council make your appearances, or parties if you're here self-represented. Ms. LaBeouf, why don't you start?
Thank you. Nicole LaBeouf at LaBeouf Law, PLLC.
Sorry, Judge. Hello. I'm sorry, Judge. Can I have just about 1 minute? Okay, just
Okay.
1 second.
On mute. Keep mute. Okay, yeah. Oh, you're right. Yeah.
I'm sorry, Judge. I'm back, Ms. LaBeouf. If you can start over.
Yeah,
Yes,
go
ma'am.
ahead.
Do you need to start, Judge, or are you ready for me?
Did you get the beginning or do I need to start over, Miss?
I'm sorry, I did not get your beginning. I had an emergency phone call to come in.
That's okay. Let's go on the record on cause number DC 1913360, David Jackson versus the Preston Tower Condominium Association. All parties and councils, please make your appearance, which means just state your name and who you represent, or if you're self-represented. Ms. LaBeouf, why don't you begin?
Nicole LaBeouf at LaBeouf Law, PLLC. Dave Jackson is trustee for the DRJ plan, and I am in my conference room, and Mr. Jackson is in here with me. I think he may log in a moment.
Jennifer Offrich and Jim Souter of Thompson Co. Cousins and Irons, and we are here for the Preston Tower Condominium Association, Your Honor. Good morning.
James Davis, heard in MEDAC PC in Houston, here for Inner City Investments.
Judge, this is Christian Shippey with Kristen Monkhouse. We're here for the recently added defendants, Bauer, Hall, Lane, Rommel, Shannon, Shaw, Wolfarth, and Zahidi.
Anyone else? If you're a party and you're not represented, please state your name. Okay, you may proceed.
Your Honor, we're here on Preston Tower Condominium Association's motion to strike the plaintiff's 7th amended petition. It adds the 22 new current or former board members. And as you know, this case has been pending since August of 2019. When we had a December hearing, I was not present, but I've reviewed it. In 2021, we were asking for an August trial setting, and the plaintiffs opposed the August date and to quote, said wanted it sooner the better. And the court agreed and set it for May. This is quite frankly a business divorce that needs to happen sooner than later. That's where I agree with opposing counsel. And so this addition of 22 additional parties and a new cause of action against the association for defamation is necessarily going to create a delay. Obviously, these parties cannot get up to speed and be prepared for the May 17th trial date that the association would like to hold. That's it in a nutshell, Judge. I really turn it to you. We'd like to go forward on May 17th to get some closure finally to this protracted litigation and want to avoid the delay. So pursuant to your discretion under Rule 215, we ask that the 7th amended petition be struck so that we can proceed to have our day in court next week as planned.
Thank you, Your Honor. Oh, I'm sorry, Mr. Davis, did you have something to add?
No, I didn't.
Okay, thank you. As you know, Judge, I'm here representing Mr. Jackson, and today we have set 2 hearings. We actually have one later today, which is our motion for continuance that was set for last Friday, along with a number of other hearings, and it was canceled because you were in trial. And so I'd like to briefly address a few points on this motion to strike. They are, I would agree, interwoven with the motion for continuance. You know, somehow at some point, I think before I even got on, Mr. Jackson was cast as the bad guy in this litigation. He is a homeowner at Preston Tower. He has a unit that sits directly under a roof that is indisputably, nobody disagrees, saturated and broken. Its useful life ended years ago, and he is suffering from the arbitrary and capricious decisions of the board members. He is the owner at the Preston Tower who has consistently asked for years for financial transparency. He's asked, why do we have huge increases in dues, but nothing's getting repaired? He's questioned the large contracts that were awarded for work that could be obtained at half the price. He's told the board members, read your insurance policies, read your contracts, take bids for the work that's being performed here, and stop doing work that favors yourself and your friends. And as a result, he's been singled out for public scorn, he's been targeted, and he's been defamed. The prior presidents of the board have said this association is run like a private club, not a business venture, and that is true. The property is suffering and Mr. Jackson's unit has been substantially reduced in value. I know you have expressed, Judge, at a prior hearing, some concern over the allegations against the board, and I have a very brief PowerPoint to go through with you. Before I say that,
let me just say this. You only have, let me see. You only have about 3 or 4 minutes to make this argument, unfortunately.
Okay, let me be very clear, Judge. This case was filed in August of 19. In September of 19, the association produced documents responsive to requests for production that were served as soon as they answered. And Judge, what they needed to produce and didn't produce until March 8th of this year, 20 days before the association members were added, was the documents that show the arbitrary and capricious behavior of the board. And that is on documentation of the same kind that Mr. Jackson produced and less. The board has paid for their own water repairs and has paid to other board members and their companies a large amount of money for making those repairs. That is the arbitrary and capricious action of the board, and that's why the board was added 20 days later. The association cannot come before you and say, this isn't fair and this is all late added, when they didn't even produce those documents until March 8th. And Judge, we were still here at a motion to compel after that, where you said to the association, you've got to amend your responses by April 25th, this last April, a couple weeks ago. You need to withdraw those objections and produce what you have. And we had to go back and ask for the privilege log that was requested in 2019. And lo and behold, I have multiple pages of documents on a privilege log. The cure for surprise or prejudice, especially when you've caused it because you withheld documents that prove the claims, but the cure for surprise or prejudice, Judge, is the continuance. And I did not know when I first appeared in this case and said Mr. Jackson deserves his day in court, that we would be dealing with these kind of discovery issues. And I recognize and I acknowledge, I'm not trying to villainize anybody. All the lawyers, as I understand it, are fairly new. And Judge, we've been working very hard. I was taking depositions last week and the week before. We allowed a second inspection of the property in March. We allowed new expert reports. But here we are, we're all trying to move this ball across the finish line. You've asked us to meet and confer about trimming down the litigation. We haven't had a chance. We've been running from one thing to another. Now it's pretrial deadlines. But Judge, this is an appropriate and timely response. It's well-founded. If I could show you the pictures, what I wanted to show you is the pictures of the condition of this property and the condition of the roof, the tree growing on the roof, that as soon as Mr. Jackson started asking questions, the letter he got saying, don't go on the roof or we'll arrest you. As soon as he said, when are we going to make these repairs? And I've got excerpts going back to 2011 on multiple roof reports saying it's a failed roof. It's at the end of its useful life. You've got to do something. And that's why the board members have been named. Instead, they're repairing their own and their friends' units. They're paying other board members to do it. The property is languishing, the unit values are going down. That's why they've been added. And they were added on the pleading deadline, and they were added 20 days after the documents that supported it were produced.
Mr. Steckler, I saw you just signed on. Did you want to say anything?
Yes, Your Honor. And I apologize for joining late. I just made an appearance in the case, so I was not correct on the time. In looking at all the documents, Your Honor, it appears this is a lawsuit by Mr. Jackson as a trustee of a plan regarding water damage to his apartment that occurred, I guess, in 2017, 2018 in Preston Towers. We're now looking at a 7th amended petition, probably one of your oldest cases on your docket, and we're adding claims of libel and slander that are, 1, likely time barred, 2, I'm not sure what they have to do with a water damage case here, and 3, my client is a member of the board who joined a year ago. What does this have to do with the damage that really occurred that's at issue in this case at the time this case was filed? This appears to be just an effort to either intimidate parties, force settlement, or delay the upcoming trial setting. I can't speak to the discovery here, but at the end of the day, this case has not changed. It's a case involving water damage to this apartment in Preston Towers, and I don't know why there's a necessity to go so far afield by a trustee, no less, of a trust that owns an apartment. And yet we see claims regarding his own individual issues. That would be completely separate in any other case. I don't know why they're being intertwined here. We've seen sort of a pattern in practice, as this court knows, of intimidations that have necessitated protective orders, which unfortunately I think we have a violation already, which is a shame. But it just is nonsensical to me, Your Honor, and I hope you'll seriously consider what's at issue, what has been pled, and what needs to be really resolved here. And a lot of this just looks like noise to me. And I'd ask the court to seriously look at those pleadings.
Does anyone want to speak on behalf of the plaintiff other than Ms. LaBeouf, or agrees with the plaintiff's position on this case? Anybody? Okay. All right. I'm going to grant the motion to strike. And then I didn't realize the continuance has been, I'm going to deny the continuance unless anybody on the defense side is requesting a continuance at this point.
No, Your Honor.
Judge, I need to make a record because I did not completely cover that continuance hearing, and I need to preserve the record. May I make my arguments?
I've already read them, but you have 40 seconds.
Thank you. We've been hampered in this case by late production on March 8th, all of the ledgers arriving last month on April 7th, 11 days before the discovery deadline and 5 weeks before trial. We could not take the fact depositions that were required because the association did not timely produce its documents, which were requested 3 years ago. We have uncovered additional evidence and a whole room full of documents, despite what was represented to this court at the last hearing, have been withheld from discovery. A motion to compel documents to be produced by April 25th. We still don't have them. The privilege log that was finally produced on April 28th needs to be set and heard. Substantial documents have been withheld. This is not, and I know Mr. Steckler is new to this case, this is not about damage in 2018 and 2019. It's about a continuing problem with the building and with the unit where it cannot be repaired, it cannot be sold, and it cannot be lived in. And the new documents that were produced by the association 3 years late show the arbitrary and capricious nature of the behavior of the board members. And so therefore we would request the continuance of the trial date so that Mr. Jackson is not deprived of his opportunity to be fully heard and to do the discovery that was due to him 3 years ago.
Ms. LaBeouf, I think you've done a great job since you've taken over this case. I think but you just took over this case. I have to look at the case as a whole and the history of the case as a whole and the diligence of your side as a whole. I can't just look at what you've done because this case is so old. If any of the defendants want to agree to continuance, I do want to hear that.
I had a call last week from a carrier for the defendants saying that they want to talk about settlement, and we haven't had time to do that. Last I heard, Mr. Davis was not opposed. He may be opposed today.
Mr. Davis.
Yes, Your Honor. On behalf of Intercity Investments, Mr. Nathan Schwartz from the LaBeouf Law Firm reached out to me on the proposed motion for continuance, and I told Mr. Schwartz on behalf of Intercity Investments, and as one of the newer appearing attorneys, that I was not opposed to the continuance.
Okay, are you advocating for the continuance, and if so, why?
Well, and to follow up on what Ms. LaBeouf stated is that one of the Intercity Investments insurers, their vice president of claims, reached out to Ms. LaBeouf to talk about to begin a discussion about a global settlement. And my marching orders were to try and get a second mediation on the calendar before the trial, which you know, with the
Let's
availability
do
of
this.
mediators now,
Let's
that's
let
just
me
not gonna
call.
happen.
I'll call Burden Mediations and see if we can get some. I don't disagree that I'd like to see you guys mediate again, but I don't want to move the trial setting. So let's see if we can get you mediation this week.
That'd be much appreciated, Your Honor.
You have reached the Office of Burden Mediations. Due to the exigencies created.
It's annoying how they do that. Let's see. So who are going to be at, who's going to actually be at the mediation? Ms. LaBeouf, Mr. Davis, and Thompson Co. Is that right?
Yeah, yes, Your Honor. And I'm familiar with that conversation. And as in most cases, you know, settlement discussions can go forward even past jury selection, even when the jury is deliberating. At all times, we're open to discussion.
Ms. James, I have Burden Mediations. Ms. James, you there?
Yes, sir, I am.
We have an emergency mediation. I know that mediators are kind of busy right now. That we needed to get in this week, and just do you want a half day or a full day, Mr. Davis?
I would think due to the various claims that a whole day would be most productive.
You have any mediators? It'd be great if King Pfeiffer, Ken Rubenstein was available, or Jim Jordan, but if no one else is, then if they're not available this week, we can figure out who else.
Those three are not available for a full day this week.
Okay, are they available for a half day?
Ken is available for a half day on Friday morning.
Okay. All right, and who are who do you have available, I guess, this week?
Let me check. Today I would have Karen Hubbard available.
Let's go after today. I think that's not realistic.
Okay, I would still have Karen Hubbard available, or Dana MacArthur,
What days?
or tomorrow.
What about the rest of the week?
On Wednesday, I would still have Karen Hubbard. Actually, Karen Hubbard is available every day this week.
Okay, what about MacArthur?
She is not available on the rest of the week. No, she's not available the rest of the week. She's booked.
Just Wednesday?
Just Tuesday.
I'm sorry, just Tuesday, sorry.
Tuesday.
So Hubbard's available every day. MacArthur's available just Tuesday. Ken's available Friday morning. Who else do you have available?
No, he's booked on those. He's not available. I'm sorry. That is pretty much it. Our mediators are booked this week.
All right, so you have Ken Rubenstein available Friday morning, Karen Hubbard available any day, and Dana MacArthur available on Tuesday. What do you guys want to do, Mr.? I'm going to let Mr. Davis kind of decide this.
I'm not from.
Mr.
I'm sorry,
Davis,
Ms. LaBeouf, I didn't hear you.
with you. Go ahead. Say, I'm asking Mr. Davis this.
I'm not familiar with any of those mediators.
You're not available, Ken. You're not familiar with Ken Rubenstein?
No, Your Honor.
Oh, wow. Okay, you must have from Dallas.
Yeah, I'm from Houston.
He's a very well-respected mediator. I'm doing a panel discussion with him on the future of remote mediations. He's very, very good, but he only has a half day. Karen Hubbard is available Tuesday through Friday, and then Dave MacArthur is available on Tuesday. I'm not as familiar with those, but Ken is excellent. It's just he only has a half day.
Dana MacArthur would be acceptable to us. I've mediated with her. She's good. She's a strong personality, and I think for personalities here, that makes sense. I'm out Friday because I have a conflicting engagement, and the closer we get to trial, of course, the harder it is.
Would Tuesday work with Dana MacArthur for everybody?
Yes, Your Honor.
Mr.
I can talk to the VP of Claims for Intercity's insurer and see if they're available.
All right. We're going to go ahead and order a mediation with Dana MacArthur for tomorrow. Let me give you the cause number. This is pretty confusing, so I'm just going to tell you who you need to contact because there's a million parties and a lot of them just got struck. And So I'll tell you which attorneys you need to reach out to, but it's DC 1913360. The plaintiff attorney is Nicole LaBeouf. Defense attorneys are James Davis. And who should they contact from Thompson Co.?
Mr. Souter or myself, Ms. Offridge, but Mr. Souter would be great.
Souter, James Souter, right?
Yes.
Yes, Your Honor.
Souder, and that's it at this point.
SOWDER, sorry.
SOWDER.
SOWDER.
Judge, it's my understanding, I was not on the case, but it's my understanding the wheels came off at the first mediation because not all the carriers were there. And I think that if it could be ordered that all the appropriate people be present, that would help.
Yeah, all appropriate people need to be present, Mr. Davis. So did you get that, Ms. James? I'm sorry. So it was Ms. LaBeouf, Mr. Souter, and Mr. Davis. There's a ton of other attorneys. You do not need to contact them. Just contact those three. Those are the only ones that are still live at this point.
Okay, and Mr. Davis, excuse me, Mr. Davis and Mr. Souter are the defense, and Ms. LaBeouf is the plaintiff?
Yeah, they're representing two different defense groups. They're two different, so they both need to be informed about it. And Mr. Davis is kind of driving the bus on this one, so we definitely want him to be there, or it sounds like he is. But
which firm is Davis with? Because we do have more than one James Davis.
What firm are you with, Mr. Davis?
Hurd and Medak PC in Houston.
I'm sorry, I did not hear that.
Hurd, HEARD, and Medak.
MEDACK.
MEDACK.
Okay, in Houston. I got that. And then the cause number again is DC 1913360.
Correct.
And this is a 3-party case. We're going to do this with Dana tomorrow for a full day.
Full day, and I assume over Zoom. Is that what you guys prefer?
No, we prefer in person.
In person. Okay.
Well, I'm going to leave it up to them. Can he do a hybrid, or does it need to be one or the other? Or can she do a hybrid, or can it need to be?
She can do a hybrid, yes.
Mr. Davis, if you want to be there in person, you can. If you want to be there remotely, you can. But you need to make sure all your levels of coverage are there.
Okay, and the VP of claims that tasked me with this mediation, he can appear by Zoom because he's not even in state.
Correct.
Okay.
He's the VP, as I understand it, for the association's carrier too. And remember, Judge, we had a motion to consolidate set for last Friday. There's a Mr. Robbie in an associated case filed by the association in Purdy's court. He's made an appearance here. We did not have our consolidation motion heard, but because the association is suing Mr. Jackson in that case too, I think they should be ordered to be here on that case as well.
Mr. Davis, what's your position on that? Because you want to do a global settlement, right?
That's what the insurer's desire is, to have this mediation to get a global settlement.
It's the same insurance company, right?
Yes.
Yes.
Ms. James, if you could just let Ms. MacArthur know that there's another lawsuit and you can talk. I have a bunch of other cases I'm trying to deal with. So the parties can reach out to you. Her name is Karen James. Her phone number is, sorry. What's your phone number, Ms. James? 214-316-8144. And just make sure, sorry. You still there? Just make sure that all the parties, if they want the folks from the other lawsuit, there's a related lawsuit that may be consolidated into this one. If they want them there as well, I have no problem with that. I think they're seeking to get a global settlement, if possible, of all claims on both sides. So, but just those parties, there's 22 other parties that were just added, and I've struck that so that none of those folks need to show up.
Somebody needs to speak for the association.
Excuse me?
Yeah. All right. Thank you, guys. Thank you, Ms. James.
Thank you.
All right. Bye-bye.
Make
sure all the appropriate people are there. Rhonda, if you're there, go ahead and prepare an order appointing Dana MacArthur on this case. And good luck. I hope it all works out.
Thank you, Judge.
Thank you, Your Honor.
Drop the CKJ Trucking. Are both sides here for that?
Your Honor, Jack Walters is here for the plaintiff.
Yes, Your Honor. Travis Casey is here for the defendant.
Okay. All right, Tony. There's a person named Grado. Is that on this case?
Don't believe so.
Not to my knowledge, Your Honor.
Okay.
And it looks like that person just dropped off.
All right, let's go on the record on DC 201778 Strope versus CKJ Trucking. Counsel, make your appearances.
Jack Walters with the Walters Law Office on behalf of plaintiff.
Travis Casey of Fee Smith on behalf of defendant.
Let's proceed.
Your Honor, this is a no evidence motion for summary judgment. It stems from an incident in which the plaintiff was a truck driver for CKJ. CKJ is a non-subscriber to workers' compensation, which has allowed this civil lawsuit as a result. And as we understand the allegations made in the petition, Mr. Stroup, the plaintiff, was driving for CKJ one day when he pulled off as a result of a flame that was on his brakes. It seems that he extinguished or partially extinguished the flame. He additionally heard his airbag deploy while he was outside his vehicle and was near to a tire that popped. And as I understand from the response to the MSJ, maybe he was very near to a tire that popped. He did not sustain physical injuries as a result of this accident, but about a year afterward, he began alleging that he sustained post-traumatic stress disorder as a result of this incident. And so he is suing his employer, CKJ, or his former employer, for the PTSD allegations. The aspects of this motion for summary judgment are four. First of all, we believe that the motion for summary judgment did not fall within the statute of limitations. This is a no evidence motion for summary judgment, so I won't go too far into it, but essentially, until recently, we did not have, through the petition or otherwise, a specific date for when the accident or this incident occurred. In the plaintiff's motion for summary judgment, they're claiming January 13th, 2019 as the date of the incident. The evidence that they rely on is a weekly haul sheet from that time period that shows that Friday, January 13th, that Mr. Stroup did not haul any loads. And so I suppose that is proffered as affirmative evidence that this is the date of the incident. Based off of the repairs that were performed, we believe that the incident would have occurred in November, which would fall outside the statute of limitations. But again, this isn't a traditional motion for summary judgment. It's a no evidence. So first of all, we think that the claim falls outside of the statute of limitations and that there's not an affirmative date that the incident occurred. The other three aspects of the motion are all damages related. First is a claim that the plaintiff cannot recover for disfigurement. As I understand the response to the motion for summary judgment, the plaintiffs concede that there is no physical injury and therefore no disfigurement under Texas law. And so I believe there's a motion to amend that aspect of the damages claim or otherwise, grant it through the motion for summary judgment. As for the other two claims, they're for mental anguish and for pain and suffering. Under Texas law, mental anguish requires serious bodily injury. And the plaintiff offered an article as their evidence from Amanda Dow as evidence that PTSD is a physical injury. As I understand the article, essentially it's that, because it affects the brain and the brain's a physical organ, it therefore is a physical injury. Ms. Dow, from what I gathered from the article, is not a doctor. She's also not an expert in this case. And so I don't know that that's credible evidence that there's a physical injury. But in addition, her article starts with a definition of PTSD namely that it's induced by traumatic experience such as serious accidents or injuries, assault or abuse, combat experience, exposure to terrorism, or substantial emotional loss. And so courts no longer require physical manifestation of symptoms, but nonetheless, we would argue that none of those elements exist in this case, from a truck driver who encountered, a situation that required him to pull over, witnessing a flame, witnessing an air or hearing an airbag deploy and seeing a tire pop. That doesn't amount to the type of shell shock. I believe she is a phrase she uses, shell shock and battle fatigue, that we traditionally associate with PTSD. The last part of the motion, Your Honor, is the claim regarding plaintiff's prayer for pain and suffering damages. Defendant's position is that this incident does not, the incident and the corresponding damages does not amount to a high degree of mental pain and distress. The standard under Texas law for which is a high degree of mental pain and distress that is more than mere worry, anxiety, vexation, embarrassment, or anger. So again, seeing a flame, hearing an airbag deploy, and or being near a tire that popped does not meet the requisite standard. And so we believe that the no evidence motion for summary judgment should be granted, despite plaintiff's allegation that he sustained PTSD as a result of the encounter from the day of the incident, whatever day that is. You're on mute, Your Honor.
Response?
Yes, Your Honor, I'll take them in turn, the 4 points. First, the statute of limitations, we contend it was December 13th, 2018, not January.
I'm sorry.
And that's fine. And that shows it was a Thursday. You'll see our calendar in there. Plaintiff had argued or testified that he went to work the day after and the day before. That would fall in line with his testimony. In addition, we've offered testimony of plaintiff's then boss, who said he didn't recall the date. He issued a statement that was exhibit to his deposition that stated it's sometime early this year, and that was a 2019 statement. So the December date would probably fall closer to January, December. At least that creates a fact question onto that. We also did receive a pay stub last Friday, which was after the filing deadline, that also shows he had a significant decrease in work that day. He would have been out of commission that day for the incident. And then as far as disfigurement goes, we do concede there's no disfigurement here, but mental anguish, we do, PTSD does produce panic attacks, can have chest pains. It is affecting an organ, which is the brain. Affects his ability, which we've provided testimony, ability to do simple things such as pay bills, just remember where to go, focus. He's testified he can't drive. He'll have lapses in memory where he doesn't know where he's going to be. So we contend that's a physical injury to his brain because it affects his daily function of just operating as a normal human being. This injury was a tire exploding next to his head. It was a significant injury. It's not just a tire popping off. My client has testified that he was right next to the tire when it exploded. We contend that is a severe event to go through, similar to shell shock. And so therefore mental anguish and pain and suffering in tandem should be allowed. But we've provided enough evidence to show that it was within the statute of limitations, and we've provided his medical records as well as testimony that he did suffer from PTSD, which, as we know, is not an onset at the time. It's diagnosed later on. So the mental anguish and pain and suffering are still in play because of what he's provided.
All right. I mean, I don't know what a jury's going to do with this, but Mr. Casey, if you could go ahead and get me a brief book on this one. So a both sides briefing in any cases that are cited by either side. You don't need to do the summary judgment standard cases, but the other cases, and submit that to the court. Can you get that to me by Friday?
Absolutely, Your Honor.
All right, we'll take this under advisement. We'll try to get you a decision as soon as possible.
Thank you.
Thank you.
May I be excused?
You may. Bye-bye.
Thanks, Jack.